Good morning. Can everybody hear me?
Good morning, Judge. Yes.
Good morning, Your Honor. Yes, I can.
Well, welcome to an oral argument session of the 5th DCA. I am joined today by Judges Traver and Neighborhouse. We are being broadcast live and recorded on YouTube this morning. And we'll begin with the first of our three cases today. This is Clocow versus Clocow. It's case number 19-2766. We will reserve 5 minutes for your rebuttal, appellant, unless you say otherwise. And with that, you may proceed.
Good morning, and may it please the court. My name is Sheila Ennis, and I'm here on behalf of David Clocow, the former husband and petitioner below in the alimony modification proceeding that brings us here today. As you will know from my briefs, it's our position that the trial judge abused his discretion in not reducing the alimony payable to the former wife, in spite of finding that a supportive relationship exists between the former wife and her live-in companion. We believe that the finding of the wife's continued needs is not supported by the competent substantial evidence and is either a math error on the face of the judgment that requires reversal, or is an arbitrary figure arrived at by including an inflated standard of living and an overemphasized standard of living that did not actually exist during the marriage. If you look at the judgment, and we believe the trial judge correctly found the supportive relationship for a number of reasons. One, the parties actually engaged in estate planning and named each other mutual beneficiaries on their life insurance policies, which certainly evidences a till death do us part mentality. They also, and the judge did make the credibility determination on this, expressed to family members and friends that they would marry, but for their desire to keep the alimony coming unabated. So we think that that is clearly supported by the evidence and a good finding. But in finding that the wife had a continued need, the judge in his order, and it's on page 2052 of the record, found that the wife had a monthly need of $6,200. However, the expenses the judge broke out in that same paragraph only add up to $4,990 something. And among the household expenses were those that the former wife's own financial affidavit showed that the boyfriend was actually paying, including the water bill and some home maintenance. So the number is bad. And the only conclusion we can reach is that the judge, who did a lot of discussion of the marital standard of living, grossed up that number essentially by assigning a value that is not stated to that standard of living. If the judge arbitrarily chose a number to turn $4,990 some dollars into $6,200, that is the sine qua non of what an abuse of discretion is. Otherwise, it's a math error on the face of the judgment, needs to be fixed. And finding the wife has that continued need, the judge also, and very important to us, failed to take into account the about $10,000 a year in spin-off income the former wife is enjoying from her investment accounts and her retirement account. Under the Niederman case, it is error. And this court has taken a position, a case not in my brief, this was not raised in the answer, so it's not in my reply, but the 5th DCA said in Duke v. Duke, and that was authored by Judge Orfinger fairly recently. In that case, there was not even a transcript. And they found the error in not considering investment income to be fundamental error on the face of the judgment that warranted reverse and remand, even without any indication of what was or was not presented below. The wife has about $440,000 total, and the retirement account statements and the investment account statements are in the record, and they show these things on its face. So we didn't have expert witnesses below. I was not trial counsel at the modification proceeding, but the statements are in evidence, and it was raised in former wife's motion for a rehearing for the judge to consider that. And what we do when we run out of money for experts is we simply take averages, and we've got 3 years worth of statements to do that. We also believe that the judge erred in finding that the former husband had a continued ability to pay, when the tax returns show and the uncontradicted testimony of the CPA, who was the only CPA who testified as a fact witness for Dr. Clocow, showed that his business had declined since entry of the final judgment. And for these reasons, we believe that the judge erred and that the matter should be reversed and remanded.
ask you a question as to, I guess this would be relevant to your point on the tax returns. I think there's an argument in your brief that the trial court failed to appreciate the significance of the business account and made a finding that that the business account failed to appreciate that both personal and business expenses were being pulled from the business account, even though that they were being categorized properly. Is that an accurate representation of the argument?
That is, although, because we had the bookkeeper testify as well, and Dr. Klockow, testified that he just uses the business account and pays for things and lets the bookkeeper and the accountant sort it out after the fact. And so they sit down each year and decide. I understand the other side says that that's not properly being done and some personal expenses are being taken, but the uncontradicted testimony of the CPA, the only CPA, was that no, this is adjusted out, and the bookkeeper testified to that same thing. I also note that there was some arguments on the other side at the end, and they're using gross business income of the practice to argue that Dr. Klockow's income was up in the $400,000 range, but that is a gross total corporate income before cost of doing business. And of course, the proper definition of income in Chapter 61 is what a business generates less the cost of doing business. And of course, Dr. Klockow in a dental practice has the cost of staff, dental hygienist, labor, rent.
There was some dispute in the record, specifically as to, for example, the expense of wine. I think your client testified that the wine was a business expense. The former wife testified that they never drank wine at the office. And there was some insinuations in that regard that although it might have been characterized as a business expense, not a personal expense, it might have been overstated. The business expenses might have been overstated on the tax return. So if the judge accepted that testimony as relevant to an overstatement of business expenses on the tax return, would that support the finding of the income in this case?
Yes, if that was accurate. As I recall from the testimony, the wine was actually purchased, I believe, as Christmas gifts for staff. I don't believe it was for consumption on the premises, but I don't have the best recollection of that. I'm sorry, but yes, the judge had the right to choose and say, "Hey, I don't think that you were careful enough with categorizing your business and personal expenses." But whether or not Dr. Klockow was construed to continuing to have the ability to pay the $5,000 a month. The alimony should nevertheless be reduced because the wife's needs are a completely separate inquiry and doesn't depend on his ability to pay. Dr. Klockow could have $1 million a month or $100,000 a month, as in the Dunn case, and it is not relevant to whether the wife's needs have changed and been reduced by virtue of the supportive relationship and her interest income.
You raised the math error in your initial brief. I can't see it.
I didn't, and I didn't actually put in there about the math. I did not, but I put in there and I'm saying today it could be a math error. At the time I wrote the brief, I'm thinking he did this because it was a standard of living. He bumped it up for that. He must have, and so that was where my argument was centered.
So, on the argument raised as to the standard of living, am I correctly characterizing the argument essentially that because their lifestyle was mortgaged, that as a matter of law cannot constitute a standard of living, or is it a competent substantial evidence issue?
It's both. There's case law, I believe it's Jaffe v. Jaffe in my brief, that says you can't use alimony to sustain a profligate standard of living, and you especially when you're dividing income from one household and having to support two households. Otherwise, you turn alimony into a lottery, and you encourage litigation to inflate expenses in order to get the highest possible amount of alimony. So it's a matter of law as well. It's competent.
But as a factual matter, if the parties are staying relevant not relevant, but they're staying on top of their expenses, all of their expenses are paid for, although instead of paying with it with credit card or income, they might be paying with it with a equity loan. How is that an inflated or unsustainable lifestyle?
Well, when things are not owned but owed, they didn't own any of these things. When they sold all the main marital assets besides the Brown and Brown stock, they sold a marital home on the river, they sold an RV, and they sold a Carver yacht, 40-foot yacht, and they each netted a grand total of $71,000. that means that, while they were probably, I didn't get any indication they were not current on their obligations. Nevertheless, they were living a lifestyle that was mortgaged. That's not the same as owning it outright, and that's not the same as affording it. That you are staying ahead of your monthly obligations is terrific. It means you're treading water. It does not mean that you actually have this lifestyle. You have a hiccup in income and everything's gone. And that's not the case. And I go back to Dunn v. Dunn, which I will point out was decided 1 month prior to the Cloco trial. And it was a kind of a shot heard round our circuit in the family law arena. And there was a lot of talk about standard of living in that case. And I think it made its way into our trial cases around that time. And standard of living got sort of temporarily re-elevated to a super factor. And I don't think that that was this court's intention in Dunn. Dunn was a good fortune marriage. Dr. Dunn owned multiple aircraft. They distributed a Learjet in the original dissolution of marriage. He was making $100,000 a month and maintained multiple homes even after the divorce. There was never a dispute as to his ability to pay. And I think that that same rationale got misapplied in this case. When you have and the judge in this case said they owned a multi-million-dollar home. No, it was a $1.1 million home with $930,000 of mortgage against it. You had a $150,000 yacht that was liened to the tune of $130,000 and secured by the marital home. I don't know what the lien was against the RV, but again, by the time they were done, there was even talk in the original final judgment, and it's in there twice. Former wife's own counsel expressed concerns there would not be any money left once everything was sold and distributed for the husband to make an equalizing payment to the wife. And in fact, he did take out a loan, and that created a temporary inflation in his Brown and Brown account during the modification trial when he had to sell stock and run it through that account. For him, was in there for a day or two to pay off an old loan that he'd taken out to satisfy his obligations in the final judgment. I guess I can preemptively address we have addressed the supportive relationship. One thing I would like to point out is, the French case, which is out of the 4th DCA, and I did refer to them as sort of outliers, no disrespect to the 4th, but they've taken a different view, especially in the early days, to the point that conflict was declared for a while between them, but nothing came of it. And it seems to me that the parties in this, or the former wife and her paramour, were very, very aware of the factors for a supportive relationship and took very measured steps to avoid the implication of the statute. And that's something that French warned against. And for example, you'll see that the companion testified repeatedly that the one reason he never gave actual cash to the former wife is that he didn't want it to be construed as being given directly to the former wife's now adult child. And of course, one of the factors finding a supportive relationship is that you have lent support to your paramour's children. So they seem to have avoided that. They're very careful to avoid not jointly titling things. But for them to have decided that $900, in some places it says $950, is this arbitrary number that is the value of the boyfriend staying there. Well, if that's the case, then at least the alimony should be reduced by $900. But I do think that that is an arbitrarily selected number designed to avoid the statute and to keep the alimony flowing. If you have no further questions of me, I'll reserve.
May it please the court, Douglas Neller, K-N-E-L-L-E-R. I represent the appellee, cross appellant Tanya Cloco. Truth and facts is a good place to start. I like to make references to the record. I like to make references to the transcript when I'm alleging facts. For example, statements from my counsel: when we run out of money for expert, we take averages. That's not in the record anywhere. She wasn't the counsel at the trial. How does she know they ran out of money for experts, so we take averages? The former husband states the former wife had estate planning, extensive estate planning. No, if you look at the record, it states they had life insurance policies for each other, but they did not, which are entered into evidence, have each other in their wills at all. No estate planning there. If the bookkeeper and the CPA specifically testified that, and let me find the record here for you, that they did not review or set apart business versus personal expenses. They said that Dr. Kloko did that, both the bookkeeper and the CPA. And I'll cite that when I come across it, but that is not what was stated there. So also, if we go to page 2 of the initial brief of the former husband, again, truth and facts here. It states the former husband is profoundly hearing impaired, required the use of DNA or ADA assistive equipment at trial. Former husband has a number of other health problems, including rotator cuff injuries, both shoulders that have to be required surgically. Number one, there's no doctors testifying for the husband. Number two, he testified when asked by his attorney, does any of this affect your ability for clients? He said, no, it does not. And the rotator cuff injuries, he admitted, were 8 to 10 years ago the surgery was. So the whole issue comes down to here, I'm going to do it in reverse order, substantial change. Because all the supported relationship statute is akin to the child support statute, 15% or $50, you presumptively have your substantial change. And that was passed, I believe, May 10th, 2005. What's interesting about that, that's about 16 years ago. And I've been practicing about 33 years doing divorce, and that's right in the halfway point of how we did it the old-fashioned way in this situation. Alleged cohabitation is substantial change. But because that was being abused, the legislature passed this substantial relationship statute. And there's nothing really different between pleading substantial change of circumstances because a person is cohabitating, hence they don't need as much money, someone's helping support them. And what the supported relationship statute states, if there's supported relationship, that may cause a reduction in termination, may. The legislature wanted this to be automatic. Every time someone's in an intimate relationship, it would have said it. So we must remember, when this litigation started, the former husband was paying $5,500 a month in alimony. There was a specific step up, step down schedule. The stipulation we gave at the morning of trial for alimony was $4,500 a month for the first 11 months or until the house sold. Now, truth and facts. In the former husband's initial brief, it states, well, that was done because he was incurring all these expenses. Nowhere in the record does it say that was why that was done. Nowhere in the stipulation given to the court. So what we do know, though, is he has substantial income, hundreds of thousands of dollars coming into his dental practice that he admits he pays personal expenses out of. He admitted that the first time around, he admits it the second time around. We have the CPA and his bookkeeper saying, no, we don't double check what he, Dr. Kloko, determines personal versus business. So that indicates to me proper analysis can only be done on the gross income versus his alimony obligation to determine if there's been a substantial change in his ability to pay. So we know in 2013 by the evidence in 2014, well, actually, let's go at 2013, the day sheets indicated a gross income of $538,000. All the day sheets are in evidence. He was paying $6,000 a month alimony then, and that would equal 13.4% of his income if he was paying $6,000 a month then. It'd be 13.4%. 2014, the day sheets again indicated $534,000, about the same in income. Again, if he was paying $6,000 a month in alimony, 13.5%. It started off at $4,500, then it went to $6,000 for X number of months, then it went to $5,500 for X number of months, and that's when we started litigation.
What is your argument? What is your argument in response to the former husband's argument that essentially the trial court failed to distinguish on the day sheets, the patients that were seen by hygienists versus the patients that were seen by him.
The day sheets tally up the total amount of money earned that day.
Right, and the record reflects that some of those patients, some of that money was incurred by patients seen by the hygienist and some by him as the dentist, correct?
Okay. Yes, but that's his business. His business involves hygienists.
Okay,
Just
so
as
sorry, go ahead.
it's irrelevant how the money's incurred. The question is, what is his gross income each year for his business? That's the question. It isn't just what is he making, it's what the staff's making. For example, in the law office, if there are other attorneys that work for me, do they bill?
Well, I think didn't the trial court think that was relevant because in support of its finding that his tax returns did not accurately reflect his personal income?
No, that's even a more smoking gun. Look at his financial affidavit he filed in 2016, when he filed this case. It says my gross income is $13,000 a month. However, when he finally got his tax returns done by trial, it showed his gross income was around the 1040 income, around the $200,000, $16,000 some odd dollars. So that's where the judge found his income. The day sheets back up with the day sheets. The reason we have day sheets for 13 and 14 is because there are no tax returns. We cannot get tax returns in discovery. So with no tax returns, we have to go on day sheets to determine the gross income, and that's what we did. They're not in evidence. So
just going back to Judge Sasso's earlier question, the challenge I'm having, and it's in the judgment where the trial court says his testimony about a diminished patient load is not borne out by his own business records. The way that I think I'm looking at that is to say that if you have, just to pick an arbitrary number, you have 5,000 patients in 2015 and you have 5,000 patients in 2017. But if in 2015, just to use the law firm analogy, 3/4 of it is partner level work and 1/4 of it is associate or paralegal work, and in 2017, those percentages switch, you're going to see a decrease in overall business income. So if we're talking about what I think the trial testimony showed, which is that there were increased amounts of work being done by hygienists at a lower rate, I'm not sure what support there is for that particular factual statement in the judgment. Does that question make sense to you?
It does. Yes and no. Let me try to answer. If I don't answer it correctly, let me know, because it started out one way, it ended up another way. So I believe you're saying there is a change in income because he showed that the people making the income changed. He was making the majority of it now, or not the majority, he was making X percentage. Now the hygienists were making Y, now they're making R&S. The issue I would submit to you is it doesn't matter who makes the money. What matters is the gross return. Maybe he's smart enough to know the business is changing, so he's going to change his business model. The issue is, what is the gross income and how does that relate to the alimony paid? Because we have to remember, there's a 20% decrease in her alimony from the date of the final judgment to present automatically. I wonder why we put a 20% decrease in there. Could it be with regard to everything he said in his petition? But that was in there. It's not stated in the record why it's in there. As you know, and there's a stipulation, you don't have to go over the statutory factors. That's mentioned twice in the brief that was never done. It's not necessary for a temporary stipulation. So during the case itself, it goes from $5,500 to $5,000 a month. That is a 10% decrease in her alimony automatically that happened during the case. Starting off from the 20 months out when he filed this, it already had gone down 10% from the $6,000 to the $5,500. So we already have a decrease in what he's paying during the case itself. And this is why that's so important. when we finally do get his 1120 statements to look at, we know in 2016, his gross income from those statements, again, that's taken with a, his gross income on those statements were $452,000, which if he's paying $5,500 per month equals 14.6% of his income per year, 14.6%. 2017, 457. In that year, he paid $61,500, 13.5%. 2018 is 1120S, 448,000. Now he's paying the $5,000 a month, 13.4%. That is the exact same number looking at the day sheets in 2013 and 2014 and 2015 if he was paying $6,000 a month in alimony. So the first issue is he's getting a second bite at the apple here by saying, I need a reduction or termination, but you're already getting a reduction during the case itself. It's already gone down 10% since the date you filed to the day of the final judgment automatically. That's happened. Did that answer your question? If not, I'd ask you to rephrase it. I can try again.
Again, I think the challenge for me is that you've got a factual finding in there by the court that doesn't seem to be supported by the evidence.
Okay, and so I'd like to work on that one more time. That's the factual finding stating that
his testimony about a diminished patient load is not borne out by his own business records.
Okay. The doctor's testimony of a diminished patient load, correct?
I'm just reading paragraph 21F of the final judgment. And you've also got in paragraph 21H talking about given the inconsistencies in former husband's testimony about how many patients he sees on an annual basis.
Yes, and that's, yes, so the...
So if you're going to use the overarching number in the day sheet to say that that's how many patients that the former husband sees, that seems to be incorrect because it's how many patients the overall business sees. And as I tried to outline the first time that I tried, and I apologize if I'm unclear, is that that can be a function of who's doing the work and at what rate they're doing it for.
Correct. I agree with you there. That his testimony is inconsistent with it. And that's why we have no other choice but to go to the gross income analysis, because this is the gross income, whether it's true or not, that his testimony is more patients, less patients. To me, that's irrelevant to the issue of what is your ability to pay. And I know I'm going to spend some time on the supportive issue in a minute, but if the court concludes that the issue is need and ability, and we end up the same place, then for purposes of where we're going, it doesn't matter if there was or was not a supportive relationship. So because of the conflict in testimony, it shows that we have no choice but to look at the gross income. And when we do that, understanding the automatic reduction, understanding the accountant and CPA both stated we don't segue out these personal expenses because he tells us what's personal, what's business. It's incorrect to say my income's gone down. Now, he can say though, for the substantial change, there's a supported relationship. He can't argue that, and the court concluded it was. However, I would submit to you that the court was incorrect as a matter of law there, especially looking at the Linstrop case. Just with regard to the concept of marriage, we know that there's case after case that states, if you find a supported relationship, you must do this with caution. Why must we do this with caution? It's because the effect of it can be life-changing. your alimony's terminated. Here, we have a former wife that when this started in 2016, I believe was 54. It's a high school graduate, long-term marriage, have a child together, stay-at-home wife, only worked during the marriage at her husband's office. And we have a allegation between us or before us that states she's in a supportive relationship. So the cases say be cautious with this because the effect is harsh. Why be cautious? Think about when you get married. If anyone, I don't know who's married, who's been married, but if you've been involved in a marriage or a wedding date, there's a lot of planning that goes on. There's classes sometimes people go to. There's real commitment. And I believe I believe the case law stating tread with caution here goes to, is that real commitment shown in their relationship that would equal a marital relationship? Now, commitment's always shown by wearing an engagement ring. Commitment's shown by referring to each other as husband and wife. A lot of the cases that find support relationship, they actually have a ceremony. That's showing commitment. When he filed this petition, it was 20 months out from the dissolution. And when we had the trial, it's about 5 years out. At this mark, regardless of the other factors, it's just too short of a time period. I'm not saying in the future they may not be in a supportive relationship, but I don't believe they are now, because what the judge put a lot, it seems to me, since he wrote about 7-8 sentences on it, he put a lot of creed into the statement of the daughter that mom told her that the only reason she wasn't married for the alimony. 1, what is the context of that statement? 2, is that statement under oath? 3, was that a joking statement? 4, would that be a statement of anything serious to the daughter? You can't, that's one statement in thousands of actions of conduct. The husband, the boyfriend was paying $900, $950 a month for rent before this. That's what he's paying now. He does it through work to the home and paying for what bills he can. The key issue in these cases, excuse me, I have a dry mouth.
We have about a minute left.
Yeah, the key issue in these cases is the boyfriend getting something from the alimony? The answer is no, he's not getting anything at all here. If you look at her financial affidavits, it shows a need at the standard of living around the divorce about $15,000 a month. She chose to live below her standard of living here. That's her choice. So every time she reduces her standard of living, we're going to come in and ask for a decrease until she's living in a tent. I mean, that's what goes on in these cases. She's not living up to her standard of living, reduce the alimony. Oh, we reduced it up. She's trying to save money. She's not living up to it again, but let's reduce it again. That's what's going on here. There's a issue of intimacy. Now on the attorney's fee issue, I don't have time. I'm not going to repeat it for you. Just please heed to it in our brief, and I appreciate it. Thank you very much. Pleasure speaking with you today.
Thank you.
I just make a few very, very quick points. I think it's pretty laid out in my brief that the evidence is very clear that the only money flowing into this 2-person household is my client's $5,000 a month permanent alimony, plus the $10,000 a year spin-off income the former wife is receiving from her investment and retirement accounts. The boyfriend testified he earned $78,000 a year, and yet he's paying nothing directly to this household. For him to suggest he paid $900 in rent when he lived on his own, now he pays $900 now, disregards that when he lived on his own, he would have had separate expenses for utilities, food, whatever, every other living expense there would be. He has now reduced his living expenses by putting all of his utilities and and amenities under that $900 a month umbrella. He's doing that courtesy of the alimony being paid to the former wife. There can be no other conclusion if that's the only cash coming into this household. As far as him saying he pays for meals out, and that's part of what they offset expenses for, if they were dating and living in separate quarters, presumably he would pay for meals out as well, at least some of them, and maybe as much as half of them. What the crux of their argument is that, what if this new relationship doesn't work out and the former wife is left, without any income at all? But alimony is not an insurance policy to underwrite the potential failure of a future relationship. You cannot hold a former spouse hostage like that. And of course, the trial court has the discretion not to terminate alimony outright, can reduce it to $1 a month or $10 a month or whatever to keep it alive. And if the wife finds herself in dire straits, she has the right to go back to court. But to perpetuate it just in case they break up is inequitable in the extreme. And as Judge Farmer's dissent, I think it was in maybe one of the Overton case, perhaps Overton 1, he said, what you're doing is you're penalizing the people who get married and fulfill the public policy of Florida that favors marriage, and you're rewarding people who avoid it just to keep alimony coming from a former spouse. The other thing I want to point out is that's happened in my opponent's argument. They, again, in deciding what percentage of income is being generated towards alimony, are using the gross business revenues. Alimony, the law is very clear on that, is based on net income. And although I admit the trial judge had trouble finding he didn't agree with Dr. Cloco's, adjusted gross income on the tax returns, I understand the judge's issue with that. But nevertheless, it is grossly improper to use total corporate income to base anything on. That is before expenses, and the definition of income requires those expenses before you arrive at true gross income coming out of that S corporation. Lastly, on the standard of living issue, I would point out that it does appear in the transcript of the original final judgment that the alimony was tiered and tiered low in the beginning. There's a couple of places. I found it on page 82 for one. It was low in the beginning because the former husband continued to have carrying costs on the yacht and the marital home pending their sale. So that was discussed between counsel on the record as part of that transcript in more than one place. And on the alimony standard of living, it also appears in that original transcript that everyone says, Dr. Cloco says, why am I having to pay for the carrying costs? This is a mutual expense on the home and the yacht. And the answer from former wife's counsel was because even after paying alimony, you still have so much more income and money than she does. And now in the modification proceeding, for the first time, former wife says, by the way, did I forget to tell everybody that $5,000 a month was never enough. And I had this standard of living that I left on the table, even though we had all this extra money. And now, oops, I meant to let everybody know that I needed more all along. The temporary order that was in place provided her $4,000 a month, and she carried on with that for 18 months without petitioning for an increase. And then she agreed to $5,000 a month after the fact. The relationship with the boyfriend, it came to light, had started in 2011, a year before Dr. Cloco filed for divorce. The cohabitation did not begin until the former wife purchased her home 11 months after the divorce was entered. And everybody testified, the boyfriend, the former wife, the boyfriend moved in immediately as soon as that house was purchased. And since then has paid no rent and has performed chores around the house. I'll point out the Gregory case from the 5th DCA. And in that case, the court remanded with instructions to terminate alimony, where the boyfriend's handyman services were not taken into account. The court here certainly did not impute income to the former wife for those services, which Gregory indicates was required. Now, Gregory did have a twist in it. This case does not, so I don't want to I'm not trying to mislead this court with the case law. There was receipt of an inheritance in that case that that former wife had distributed to a family member and led this court to believe she didn't have a continued need. So in the interest of candor to the tribunal, I point out that distinction. I was actually co-trial counsel in Gregory, so I remember it well. And in that case, Judge Beck had reduced the alimony and the 5th DCA went ahead and terminated it. But the reduction was appropriate for the boyfriend's skilled labor and services around the home. If you have nothing further for me, I will leave you with 1 minute and 30 seconds.
Anything else? All right, thank you very much. We will be in recess.
Thank you so much for your time today. Thank you, Mr. Neller. Pleasure as always.
You bet, Ms. Ennis.